I just want to briefly introduce the panelists that are here. Many of you probably know them, but just quickly do that. On the far end is Joe Warren from Gibson Dunn. Joe and I actually were involved in a very large environmental case, and I know you've done some other very high-profile environmental matters. Kirk Ogroski is with Arnold and Porter in D.C. Recently, Kirk represented, it's Dr. Melgen, is that how you say it? Who was also charged with Senator Menendez in New Jersey. Next to him is Ray Brown. Ray represented Senator Menendez in the case along with Abby Bloll, and he's with the law firm of Greenbaum, Rowe, Smith, and Davis in New Jersey. And then finally, Hank Asbell is with Jones Day in D.C., and many of you know that you represented the former Virginia Governor Bob O'Donnell on appeal, correct?
At trial and on appeal.
At trial and on appeal, okay. So those are just the most recent matters that these folks on the panel have handled. They've had many, many more, but we want to get to some of the information. Now, this is a town hall, and what that means is that you may have questions that you want to ask. I had questions that I wanted to ask them, so I'm lucky to be the moderator. But please feel free, if there's some follow-up or something that you'd like to know, if we can talk about it, we will. Of course, one of the biggest, I think we're going to start off with one of the biggest issues in high-profile cases is the media, and how the media sort of prevails from the beginning of a case, whether it's pre-indictment all the way through sentencing. And it's one of the things that has to be dealt with. And so I'm going to turn to the panel and ask them in pre-indictment, okay, so now we're talking about grand jury investigations. What strategies do you use to deal with the media, if any? And so I'm not going to call on anybody, just talk.
Sure. I think the media is a constant two-edged sword, and I think you have to. It's very case specific. And I think a case that we represented, a guy named Joseph Cassano, who was labeled public enemy #1 in the financial crisis. He's one of the architects of the credit derivative swaps in the London office of AIG, and Anderson Cooper labeled him public enemy #1, which I didn't think was very nice. And so the real question is, how did we address a guy that was getting covered all the time, and did we engage with them on background or directly? And in that matter, we engaged on background very extensively with the press, but never for attribution. Of course, you need a trusting press corps to be able to do that. We didn't get burned in that case, but I think many of our colleagues and myself have gotten burned over the time by press who say, yes, this is on background, and all of a sudden, but the quote is too juicy or the fact pattern is too much that they'll burn their source. So, Kirk, what's your experience been?
So maybe this is obvious, but if no one knows that you're under investigation, you don't say anything to anybody. But once it's out in the public, I think what you would do, which is talk on background to people to try to, get the story out, at least your side of the story. So that, it doesn't take a lot of work, but it usually is helpful to identify the right media people to talk to, because there are some young folks out there that I've talked to that tend to not grasp all the legal issues and what's happening in the case or where you're at in the case. So getting to the right person and figuring out how to explain a situation pre-indictment is important. And hopefully convince them that there's not going to be an indictment.
So it strikes me that one of the things that as a craft we need to keep uppermost in our minds is that it's essential to separate the lawyer's ego from the needs of the client, especially in the pre-indictment phase, where, as Kirk suggests, it may be best to not say anything at all. I think that the wonders of the marketing opportunity that's presented by a potentially high-profile client sometimes tempt some of our colleagues into speaking either about things they ought not to talk about or speaking when it's best not to talk. So certainly in the pre-indictment phase, it's necessary to have a clear understanding of when you ought to speak and when you ought not to speak, when sometimes you ought not to even surface, if it's possible.
I'll just add a couple of things. Joe said it was a two-edged sword. I think it's a one-edged sword, and it's always used against me. I do not trust the press. And I've never, I don't trust the press, and I don't think I've ever, I've never seen anyone or known anyone who's been successful at trying to manipulate the press. And if you're representing somebody who's the high-profile target of a criminal investigation, the public is not going to generally be on your side. Also in the pre-indictment phase, unless you get very close to trial, and even then, I don't necessarily know what my story is going to be or what the whole story is going to be. We don't have access to the facts. You have your client's version, and you're guessing about some of the things that the prosecution may know and try to use against your client. So I try to stay away from the press, basically, because I don't think they're going to be helpful. And at most, I give them names of surrogates, friends of the client, other lawyers who I think are friendly to the defense function, who might comment in ways that might be favorable to my client. But I generally try not to manipulate that. And you're always facing leaks during grand juries, which are very, very problematic. And sometimes require you to respond. I do not think in general that federal prosecutors are responsible directly for the leaks. I think they're honorable, and they would be trained not to do that, and they would be very frightened after Stevens to engage in that kind of conduct. But the agents always leak. In my experience, that's what the source of the leaks is, and it's impossible to track the stuff down. I don't want to get into a food fight about the leaks before the trial, and then you're litigating against Cahill, Gordon, and Williams and Conley on First Amendment issues, et cetera. It's a real distraction. But in general, unless you've got something really pithy and really interesting to say, a real great soundbite in the pre-indictment phase, I try to stay away from it. The closer you get to the indictment, obviously, the more problems you have with fair trial free press rules in many jurisdictions. If you know that indictment is imminent, basically, you're restricted as a defense attorney from saying virtually anything. So, you might have some leeway 6 months in advance of the indictment or a year in advance of the indictment, but really, you're just, you're floundering around because you really don't know where it's going to go.
Well, as Hank said, one of the issues is that post-indictment, you have to deal with various rules about the court rules, about what you can and can't say. And of course, then the press is always on you. They want comments, et cetera, and we all know that, as most of our courts don't allow us to say much of anything. Kirk, I'm going to ask you, obviously, in the recent case that you had, you were dealing with a lot of publicity during, actually pre-trial, from the Department of Justice, press releases, et cetera. Why don't you tell us a little bit about that?
So, why don't I start with my favorite motion that we filed before trial. In West Palm Beach, when they executed a search warrant on my client's office, the reporter for the local news station stepped up with a microphone in his hand right outside his office and said, "We're here before the FBI arrived." And of course, went on and covered the story, and the FBI shows up, and they're in their vests, and we had previously requested that the agents and the government not engage in this sort of activity. The motion didn't get much traction with the court, actually, although I thought it should have. But after that date, we had continuous leaks. We had over and over again the agents, at least we assume it was the agents, because I think Hank is right that most of the AUSAs that we were dealing with, we assumed were being not leaking to the media. But we had almost a constant daily reporting after the search warrant from that point on, with all kinds of things that were both salacious and untrue. The ones that were untrue are the ones that we tried, at least on background, to clarify. When they were leaking things about my client and his extramarital affairs with a number of different people, we tried to address those as best we could, But then things got carried away. One thing leads to another, and there were media reports on a number of websites involving minors, involving all kinds of things, and we tried to stay on top of that as best we could to get the record corrected on those. But it was just, once the search warrant happened, it was just kind of a constant daily drip.
So, as every criminal defense lawyer knows, truth is an elusive concept. So that one of the challenges that we faced was that when you're representing public officials, it's especially difficult. And I'm amused by the talking heads who can endlessly say, well, I wouldn't represent Trump because he's hard to control. Well, if controlling clients were easy, we wouldn't have anything to do. It's the art of establishing a relationship, especially with a public official or a CEO or a member of the Senate who is used to speaking. So one of the things we faced at trial was a CNN videotape which Senator Menendez had given an interview in which his facts were wrong, but his theme was right. The theme that helped us was friendship, and that turned out to be the key to our defense all the way through until the end. But some of the facts in the CNN clip were sufficiently inaccurate that the government chose to use that clip at trial. So as you get closer to trial, your capacity to forge a modus vivendi becomes critical. So you have a press team. This investigation really started with the press, as Kirk noted, and they were there from the beginning. And if you have a public official, he's got press people, and they're used to going tit for tat with the press. And you've got to find a way to discipline that group and make them say either nothing or only those few things that you can afford to say that are kind of simple. I mean, you don't want every story to be lacking something from the defense. So you'd like them always to be saying, the senator said or his lawyer said there was a long friendship. Beyond that, you don't want to go into details. So you'd like every story to start there, and you'd like it to pretty much end. So having a message, and as Hank says, if you can't open, if you're not prepared to articulate your theory of the case, you're not prepared to have any interaction with the press. It has to be tightly controlled. You have to be very careful. And then there's a problem of, I guess, one of our favorite stories, which is the government filed a pretrial statement of the case in which it talked about Beyonce and other people who had nothing to do with the case and
So-
went to a place which was not where our clients were.
So just to be clear,
Sure.
what Ray's talking about is, we're picking a jury on Monday morning, and on Friday, about 3 o'clock in the afternoon, the government files a 20-page trial brief that is just a transcript of the opening statement. And it was not called for by the judge, and we kind of objected and said, we would have filed one too had we known that the government was going to do this. But all the local papers and all the national papers kind of picked up on this pretrial brief that they filed, which included references to George Clooney vacationing at my client's house and all kinds of stuff that was not true.
And we didn't want to tangle with the beehive because Beyonce was mentioned. So we had to really sort of have a low-key response, but one that sort of, and it turns out, by the way, because in New Jersey, we never get to talk to jurors. We have a local rule that prohibits it, which is adopted by the district court. And so for me, this was like heaven because after the mistrial, the judge said the government could do it, so we had to do it. And it turns out that the jurors were factoring in the exaggerations and hyperbole from this memo and the government statements and saying, why did the government exaggerate? As it turned out that there was hyperbole there. And trying to, in a way, counteract the exaggeration. In a way, the hyperbole hurt the government long term. But for us in the moment, it was how do we respond to this without exacerbating the problem?
Right, but if I were a judge in that case, I would have lost my cool for a number of reasons. One is we had engaged in a very lengthy jury questionnaire. We had hundreds of people that had filled out the questionnaire. We had whittled it down. This had been going on for weeks. We were really in the middle of jury selection when they filed this brief, which was, anyone that would look at it would know that this brief was not targeted to anyone but the media. It was a narrative opening statement filed the Friday afternoon before we come in to pick the jury. And it was, of course, on every Saturday paper. So-
And the level of the hyperbole is such, not to get too much into the weeds, that Casa del Campo is a place, and there is a big 5-star hotel there. That's where Clooney and Beyonce and those people stayed. My client stayed in his client's house and slept next to his kid's bunk bed. So the government had to know sooner or later those facts would emerge. And so the hyperbole, which came from the press statements, which got a lot of attention, ultimately hurt the government. But at the end of the day, at the time it was happening, as Kirk says, in the middle of jury selection, we had to decide, would we respond, and how do we respond in a way that doesn't elevate the profile of this discourse?
Did the jurors read this?
Yeah.
All the jurors that sat
Well, they
through the
didn't
trial
read
had
it, but they said they,
So,
go ahead.
yeah, so it was interesting in the first, I mean, I assume that you're gonna have members of the jury that are gonna see the media, because it's, with the way things work in constant communication, everyone's got a smartphone, everyone's on the
Well, and
internet.
everything gets retweeted, recycled, right?
Exactly.
They
So-
did turn the pushes off. I mean, we got them to turn the pushes off.
Well, but one way or the other, I'm gonna make the assumption that they're seeing it, and what happened at the end of the day was, we lost a juror about a week into deliberation, and she came out and said a lot of things that were great for the defense. The first thing she said was, I didn't see any corruption on behalf of the defendants, the only corruption I saw was the government. And she gives this great statement, it's all over the news. Well, that time, the judge says, we're gonna bring in the jurors one by one and see if they saw this. And lo and behold, he says to the panel, how many of you saw this? And about half the jury raised their hand, even though they've been instructed not to look at the media. So once half the jury raises their hand, he does one by one, brings the jurors in and said, what have you seen? And through that process, we learned that there were a number of jurors that, notwithstanding the court's instruction that they shouldn't be looking at the media, admitted, to the court that they'd been looking at the media. And I credit them for that. It didn't get us a mistrial, at least on that basis.
But news travels in almost an asthmatic way, because in the post-interviews, they were pro-defense jurors. They seemed to be, by the end of the trial, they were talking candidly, said, well, we didn't read the papers, but somehow we heard about it. I mean, they would go to work on Fridays. They had spouses and relatives, and so inevitably.
There was one article about my client in particular that just blew me away. It was a headline in the New Jersey paper that said, "The things the jury won't know about defendant Melgen." It was almost like, please read me, right? It went through all the stuff, of course, that had been kept out and excluded by the judge, and it was pretty brutal. And I just had to hunker down and hope that didn't kill me.
One of the things that might be worthwhile going back to is the point that Ray made, is the PR professionals surrounding a client. One of the challenges, whether it's a public official and their PR spokesperson, or in a corporate setting with the mavens of the media who are in the public relations function, who whisper to the corporate entity or the CEO saying, they don't know the lawyers, they don't know what they're doing. I know the media, and this is the way how you ought to handle this. That's a hard genie to keep in the bottle, I think, for all of us. And they have sidebar conversations. Even if you think you have it's set, then all of a sudden, early next morning, the CEO will come back and said, I've been thinking about this, and it's quite clear that the media people have intersected the CEO, her or him again, and said, here's the way you really ought to do it. Because really, Warren doesn't know what he's talking about here, because I know the Charlotte newspapers, and this is how they're going to package this. That is one of the biggest challenges, I think, either pre or post indictment, is to keep the narrative going.
Well, the truth is, they are right. They do know them better than we do, and they're better at it than we are. That's their full-time job. It's not ours. And you're right. I mean, like Governor McDonnell had a whole kitchen cabinet of advisors with respect to press issues, and they had a full press secretary and staff. And they want to fight this stuff every day, and they've got to be out in the press every day about his duties as a governor. And we're trying to have minimal conversation at all in the press about this case and the investigation. But it's real hard to keep it under wraps. And I didn't see a lot of skill being exercised. There were a couple of sound bites that came out, like the only quid pro quo in this case is the government's deal with Johnny Williams, who was the major cooperator. That was a good sound bite, but there weren't many. And it's, again, you don't know all the facts. And you don't want, and these things come back to haunt you. They're going to come back to haunt you in the trial. They may be party admissions if you're running your mouth as the lawyer for your client.
I also think we have to concede that the legal standards while it's a clearly articulated, is not easily applied. I mean, the substantial impact standard is interesting, except that, here's an example that we're not involved in. I wasn't. Gates's lawyer, after the first Gates-Manafort indictment, says something to the effect that this shows that Trump didn't collude with the Russians, which I think most people interpreted as a plea for a pardon. But it was clearly something said in the court of public opinion. And it seems to me that you could certainly take Justice Kennedy's language in Gentile as saying that's justified. The judge drags them back and issues what the press calls a gag order, but all she does is cite the local rule in Gentile. So the question of clarifying the standard, of knowing beyond judge to judge what the standards are, is not so easy. Clearly, all of this is designed to impress the veneer. You can't do it improperly, but you can sort of respond. And there isn't a clear guideline. And lawyers have to be, therefore, quite cautious from an ethical point of view. And from a defense point of view, you don't want to incite the government. If the government has behaved to a certain point, you certainly don't want to put them in a position to retaliate. So it's a very nuanced and subtle process. Meanwhile, with high-profile people, you're fighting against their hangers-on, their press people who want to be aggressive and respond tit for tat to everything that's said in the public space.
And Ray, knowing your judge.
Yes.
Absolutely
That's the
knowing encyclopedically how your judge, look at that comment and say, how will she respond to that? You know, and knowing that in spades, to know that however chess move you make, you're gonna find yourself the next morning saying, Mr. Warren, what the hell were you doing saying this, or allowing your client to say this, or allowing the surrogates to say this?
I want to go back to, we're talking about, the government's use of motions. How about the defense use of motions to get the word out there?
Yeah, this is an interesting segue. In the McDonald case, the government was leaking throughout the grand jury phase of the case, and there's really not much we could do about it. And then we knew that the indictment, I'm sorry. And then we knew they were leaking throughout the grand jury phase. We knew the indictment was about to be issued. So our response essentially to that was twofold. One, the governor, on the day the indictment was returned, that afternoon gave a press conference in the foyer of one of his daughter's lawyers' law firms in Richmond. And the governor only had his wife and and a couple of his family members with him. No lawyers were around him when he made a statement in response to the indictment. That obviously was very carefully thought out, both before and after we had seen the indictment. And secondly, literally within 30 minutes of the indictment hitting the clerk's office, we filed two major motions. We called these our day one motions. And the first motion basically was complaining about asking for a Brady order, because we talked about the fact that we'd had negotiations with the government and they clearly didn't understand what Brady was. So we wanted them to be ordered to give us what we were entitled to. The second motion asked for the minutes of the grand jury where the government instructed the grand jurors on the law relating to what was an official act. We were confident from negotiations with the government that they didn't understand the law. We told them that from the start, and ultimately it goes to the Supreme Court and they get told that they didn't understand the law. But we filed this motion basically saying that they clearly don't understand the law. They obviously had to misinstruct the grand jury, or there is no possibility that an indictment would be returned. But so these things hit the press literally at the same time the indictment did. Fast forward, a few days later, we go into court and for the arraignment and the bond hearing, and the judge, and per Joe's comment, we don't know who the judge is going to be until the indictment is filed, and then in our case, was randomly assigned. So we get in front of the judge in the case, and he knew we had filed the motions. He knew that the client had given a press conference. He knew the government had been leaking, and he just looks at all of us and, okay, the game playing with the press is over right now. And I was ready for him to look at me only, as opposed to me and the prosecutor. Because I would have been really angry if he had looked at me only. But everybody just kept quiet and tried to keep it mute from that point. But we got a lot of flack from the magistrate judge on that day about the client's press conference. And the magistrate judge is, is like, You know, I know you're not a member of the bar in Virginia, Mr. Asbill. I said, yeah, Judge, I've practiced here a lot, though. What's the issue? Well, you know, we got this fair trial, free press rule. I'm going, yeah, I know. I've read it 100 times. What's the issue? You know, your client gave a press conference. I'm going, yeah, what's the issue? He says, well, your client's a lawyer. And I said, yeah, but he's not a lawyer in this case. He's got First Amendment rights, and this rule obviously does not apply to him. And then, you know, the magistrate judge is sort of scratching his head trying to figure out whether I was right or wrong, but then he stopped harassing me about it. But, you know, they're very sensitive about it. And you know, and the bottom line is there's no balance here. You know, you get leaks all the way up to you're indicted. You can't talk. They file an indictment, which is drafted to impress jurors. And then if they file these trial briefs, that's insult to injury. You know, it's a real difficult situation to deal with.
Well, they must have done a big press conference when they did the indictment.
Oh, yeah,
right?
they had a press conference, and yeah, they did do a press conference when they issued the indictment. And then they try not to expand beyond the four corners of the indictment, which is a press statement to begin with, so they don't have to stray very far. But yeah, I mean, it was, I was never able to, I mean, I could keep track of what was going on in the press. I could figure out what the themes were on a regular basis during the trial. But in terms of trying to manipulate it or control it or impact it in ways that were favorable to the client, you know, is beyond my capability.
When, you know, some folks believe in crafting sound bites in their case, that they know that the media is following the trial, and they, you know, they purposefully think about things that the media will pick up and play with. Have any of you had any experiences with that or even thought about doing that? Or done it unintentionally?
I have done it unintentionally. I asked a couple of questions that would end up getting a lot of media play, but the questions were really crafted for the jury, or for me to make argument on later, not so much for the media. But what amazes me about some of the things that I saw happening day to day in a long, heavily covered trial, you know, with an overflow courtroom is, it's kind of like this thing with subject and target, right? People hear what they want to hear. Fox News says he's not a target, case over. MSNBC says he's a subject, he's going to be indicted, right? So when you're in a big case like this, I would ask a question, and the Daily Caller would then report it as, you know, he's playing the race card. And then CNN would say, well, these guys are both Hispanic Americans, so it strengthened their friendship. So you don't know who's listening in the courtroom and how they're going to hear what the question is or what the statement is and how they're going to report it out. But I walked around for 2 weeks being asked questions about why I was playing the race card in this case, and I quite honestly didn't think that I was playing it.
So it adds two dimensions. One is you're aware when you ask questions or make arguments that the press is going to pick it up and spin it, and that can't be your primary concern. But the other is it's a complex dynamic with a client. If you have a client who's lived in that universe, and the things you say in court are going to affect them in that universe, no matter how many times you say your liberty is more important than your office, that's a person who's lived his or her entire life in a different realm. And so what you have to do is constantly communicate to the client that you're fighting this battle, and he or she is just going to have to pick up the cudgels when it's all over and hopefully renew those other battles, because they're hearing every comment through the ear of the political realities. And that's a great complication in terms of your relationship to your client. So it is four-dimensional, but your focus has to be on the jury.
Well, and Ray, I think that where it gets particular thing is a witness that doesn't hurt you at all,
Right.
and you say to the client, I'm not gonna question this person, and they say, what do you mean you're not gonna question this person? You know, you got to counterpunch, you know, and you say this person didn't hurt us one whit, you know, and I want to be able to say in closing argument, the government called 42 witnesses. 4 of them mentioned my client's name, and all of them were in an exonerating way in things. So you have to acquit, ladies and gentlemen, and yet your client's sitting there saying, come on, damn it, Joe, get up there and punch him.
And there's nothing
Ask some questions, generate some evidence
That's
for the
right,
prosecution.
yeah, right.
There's nothing harder than taking a human being out of the frame of reference in which they've existed their entire life to the more narrow universe that we inhabit, which is the judge, the jury, and what they're going to hear. And it's extremely challenging, and it involves constant communication, sometimes constant battles.
There's a guy who's been a trial lawyer who's in his very deep in his fourth quarter of his life, Kenny Robinson in DC. In multi-defendant cases, he would always figure out a way to get removed from every other defendant, try to get in a corner and with his client and kind of hide, in effect, in the courtroom. And then when the jury says, "You haven't seen me very much, because this case isn't about me. It's about all those other people, but it's not about me. And I've been over here in this corner." But it was always one of his tactics. He'd grab a place very quick early on to try to do it and say, "I've staked out this territory. I'm different than the rest of you."
Earlier we talked about social media and its impact on jurors. Recently I learned that, and if anybody's here was involved in the Casey Anthony case, I read that the attorneys hired folks to watch social media, and they were using that information to help craft some of their arguments. Now, Casey Anthony's case obviously wasn't a white collar case. Do you all think that might be something that would impact on what you do? Or have you ever done it? I mean, I've looked at social media during trials, but I've never used what was out there because there's so much.
Yeah, extensively in a number of cases where, in fact, we've generated evidence from social media. You have to be careful. There are a number of ethical constraints. You can't pretend to, in most jurisdictions, you can't pretend to be who you're not. But social media is another vein of communication in which clients, witnesses, and victims or alleged victims communicate constantly. You can't, I think, try almost any case that has any public interest or where there's a large community of people, even if it's not public, and not be trying to monitor the activity on social media because it's part of the means of communication. All you do is walk in the hallway of the courthouse and see everybody on a phone. And when don't have it up to their ear, it's because they're communicating by text, by email, sometimes on Facebook and other media, and there's no way to do jury selection. We had to the judge allowed the defense to walk through how to cut pushes off for the jurors in the jury selection process, and there's a growing literature about how judges have to gear a voir dire process to social media. You can't ignore it.
And I think what you're beginning to see is people come out of the woodwork, Ray, witnesses on the social media, because they read something. So we've had a couple of matters just in the investigative stage where people say, "I've read this, I think that's wrong," and they've called us up, and with valuable insight. So that's which we couldn't have normally have kind of discovered because it was kind of something that wasn't in our investigative plan to try to find these people, in that they've kind of raised their hand and stepped forward.
Well, and everybody blogs now. That's the, that's the problem. And there aren't any standards or any journalistic standards for most bloggers, and they can say what they want and do what they want, and that also surrounds these kinds of cases.
Yeah, we had a nice witness who blogged about our judge before taking the stand with some really
Yes.
kind words.
Yes. A friend of our client who said the judge was basically an idiot. And he thought he was being helpful. He's a lawyer, too. Makes you wonder. He actually not only is. Well, let me tell you one quick story, and maybe this will fuel your paranoia. And if you're in the room, you're already paranoid, so it's just an add-on. This guy was a witness, very difficult witness to handle. He's a defense witness. This is 9th week of a 10-week trial, and he's testifying. We went from 9:30 to 11:30, and then the rest of the day, 2:30 to 3 so he had one break. So he's testifying, and at 9:25, the judge decides to call the break and turns to the jury and sua sponte says, for the first time in the trial, it's up to you, of course, to evaluate the credibility of all witnesses using those tools you've built up over a lifetime. And we go scattering off to sidebar, and they just, all right, when the jury comes back, So when the jury came back, he gave a corrective charge, which was the basic standard charge on credibility. So we're interviewing the jurors after the trial. They said, "Oh, you mean the guy the judge told us was a liar?" So all that stuff about charges and stuff. But on the other hand, they said, "We knew by then the judge didn't like the defense, so we didn't pay attention to it." So layers and layers. That was...
Yeah, one little side note about bloggers, because it's just so unusual in my trial. the government targeted a juror, the juror in seat number 1. They knew from his demeanor in the courtroom after 2 weeks that he favored the defense, clearly favored the defense. And he had a lot of government contract business, et cetera. So the government, we didn't know it at the time, but what they were doing was investigating this guy to see if there were any problems in his government contracting. But they really wanted to get him off the jury, and they were behind the scenes doing this. We had a chambers conference that was under seal about this juror because it comes out later, but the juror basically it talks to his civil lawyer, and he tells his civil lawyer that he's on this trial, with this Governor McDonald trial, and he's the foreperson, and he assumes that because he's seated in seat number 1. He hadn't been told he's the foreperson, but he had been on a state jury where the first seat was the foreman. And he says these jurors are from all over the place, namely all over the state, and I don't really know what's going on, et cetera, and I don't know how I'm supposed to be a juror in this case or how to handle it. So the lawyer tells him, I can't really talk to you about this, basically. And then the lawyer goes and calls the prosecutors and tells them about this conversation with the client. And the prosecutors notify, after they interview the lawyer for an hour, and they spend a lot of time thinking about it, then they call us up at midnight and tell us that this has occurred, and they want to have a chambers conference the next morning. So we get into the chambers conference, and they're trying to get this juror cut for talking about the fact that he's on the case with his civil lawyer. And the press had reported the names of these people. So there was no secret about who was on the trial, but they're saying the very fact that he's talking about being on the trial ought to get him cut. So we have this lengthy argument in chambers, and initially the judge refuses to grant the government's motion to cut the guy. But it's all sealed. I go home for a weekend for 24 hours in the middle of the trial when this is occurring, and only time I went home, overnight even. And I get home, and my wife is telling me that, she's quoting verbatim what happened in this sealed chambers conference. And I'm going, how do you know anything about this, et cetera? And she said she couldn't sleep the night before. She gets up, and she has an alert on the computer for this case, a Google alert, and she starts reading a Washington Post blog from one of the Post reporters that hated us, reporting about this chambers conference. And she had it down cold and verbatim, basically. And obviously there was this leak to the Post reporter about what had occurred in chambers, and it's being blogged by the Washington Post. We then try to go and find it, and the Post has taken down the blog. And there's no way to resurrect that unless you make the Post put it back up again. And then you get into this whole battle with the law firms that represent the media in First Amendment cases. So the lesson I learned, basically, and we would obviously like to use that to create a lot of havoc in the trial and to get the prosecutors in trouble, et cetera, have an investigation about how this occurred. But what I learned is if you see anything on a blog, you better take a screenshot of it, because they don't last forever. And if you see anything weird, or any of your people that are monitoring stuff see anything weird, you've got to memorialize it instantly. But it was a very strange and unsettling experience, obviously, to have this occur. But I'm going to litigate this motion and put my wife on the stand to claim that she's seen this blog that nobody else has seen, et cetera. So it was awkward.
I want to switch gears a little bit and talk a little about what we sometimes call the talking heads. These are the folks who are allegedly our colleagues who are out commenting about our trials. They're commenting about what goes on in the case. They're commenting about strategy. They're commenting about evidence, sometimes things that aren't on the record. I'm sure probably all of you have seen or heard of that. How have you been able to deal with it, especially the things that are just downright wrong, or they're putting out wrong information?
Well, I think you can you could tell reporters if you want to talk to somebody who really knows what they're talking about. Here's the names of a couple of folks that understand the legal issues in the case or whatever, and you can try to steer or refer them to people who really do know what they're talking about. Personally, I find it offensive for people to be talking about my case and my strategy when they have no clue what they're talking about or what they're doing, and I've not talked to them. And God help us if they stumble onto something by accident that I would rather not have been expressed in the media, basically. But my view of it is, I mean, from a defense perspective, if I would never say anything about somebody else's case that was that would hurt the defense. I just would never do that. I wouldn't comment on anything in a way that possibly gave the government an edge against a friend of mine who's the defense attorney, representing his client. I wouldn't do that. I find it offensive. I think it's really only about, it's not about educating the public. It's about the lawyer's ego and desire to get press for their own personal benefit. But I really find it quite distasteful and annoying.
Yeah, I guess I would agree with Hank. I think in this context, in New Jersey, why the government chose to bring this indictment in New Jersey, I'll never know. But we had an advantage because we knew most of the lawyers who were the kind of people that were traditionally sought out by the press for comments, and we were not concerned because most of them had the ethos of looking at things from a point of view of due process and of looking at issues and being honest commentators. And I think by and large, if anything, the defense was helped in this case because, number one, we had a defense, and number two, most of the comments that were made were comments that were fair and not unhelpful. And it was done in the context of a relatively small state where everybody knows everybody and where it's very likely that people commenting are going to employ or be affected by the values that Hank just articulated.
One of the things that was interesting about our case is they kept citing Hank's case. The jury's having such a hard time with this because of the McDonald decision from the Supreme Court. Well, our judge glossed over McDonald and just instructed the jury on McDonald, and it didn't help us a lick. We argued it, and we thought the judge got it dead wrong. But every talking head that popped up on these TVs talking about it said, well, they're obviously having a hard time because the government's got it tough now because Hank did such a great job. This McDonald case makes it impossible to convict anyone. But if you were in the courtroom when the judge was instructing the jury on McDonald, in our case, most of the jurors probably didn't even realize it was that there was an issue there. I mean, the judge just instructed the jury, and we moved straight on.
No, I mean, my case was about the quo, yours is about the pro. Right?
That's true.
But also, I think that there is, as Kirk suggests, a leitmotif among the press that thinks that McDonald is part of some broad, maybe they even go back as far as McCormick, which was more important to us than McDonald in the end, a broad, unreasonable restriction on the United States government and its ability to root out corruption. I mean, that's sort of a narrative. And I think it is possible, I agree with you about not trusting the press, but it's possible to have sort of jurisprudential conversations with more intelligent members of the press, say, you're getting this all wrong. There are underlying values here about fair trial that ought to be looked at. But there is this sort of evolved notion among people in the press who think they're cognoscentes that somehow the government is being unreasonably restricted in its ability to pursue the corrupt politicians.
Yeah, well, they don't like your clients. I mean, these are friends and family are the people that like politicians. I may be mistaken, but I was always of the view that the rule of law applied to the government in addition to my clients.
Well, and I think it's particularly true where cases emanate from investigative reporting work. Those cases uniquely have this sort of challenge to it, where the Washington Post or the Wall Street Journal or the Times or your New Jersey newspaper, Newark, does an investigative series of investigative articles, and then that is the launch pad for the investigation itself. That they're always going to want to advance the thesis of their underlying investigative reporting.
Yeah, so they feed off of each other.
Right.
But even the question of where investigative reporting starts, I mean, it's always been the theory of many in the defense camp, for example, that the Menendez investigation started with leaks from intelligence sources, whether the United States intelligence sources or other countries. So the question is that, I'm sure there was follow-up, but whether the investigative reporting started there, because all the reporting was clearly ideological from the beginning. It wasn't the mainstream media that started that story.
Well, how about the reporters who call you during the trial and say that they're going to run a story about something that most of the time is wrong, and they want you to comment on it, or they want you to give information about it? How do you handle that when they're trying to engage you, right? They're trying to get information, and a lot of times they're saying, I'm running a story on blank. Do you have any comment about that?
Yeah, if they're going to run a story that I know without a doubt is false and harmful to the client, I will make comments not for attribution, that if you run this story, I'm going to sue you, period. It's completely false, it's wrong, it's really harmful to my client, et cetera, and you don't know what you're talking about, and you better go back and redo your investigation. But if you print what you're telling me you're going to print, I will sue you. I think you've got an ethical obligation to stop false press in that way, ethical obligation for your client to stop false press in that way if you know for sure that it is in fact false. So that's the only real time that during the trial that I would talk to the press about anything is when they told me they were going to run something that was really particularly harmful.
And maybe to hone in on that, Hank.
So the
if
quote
it-
would be, I will sue you.
I said not for attribution.
But where that's particularly true, if you have some document that can fundamentally rebut it, and I'll often send on that document to say, and here's why you're wrong.
I mean, we keep bashing on the press a little bit in these blogs. I will say there was one writer that covered our trial that actually sat in the courtroom and I thought did a very responsible job. And I didn't run back to the hotel, you've got work every day, but at the end of the day, I viewed it as part of my job to read what was out there because I assumed that at least somebody on the jury might be looking at it. And there was one reporter that I thought did a very workmanlike job of covering the trial, and it wasn't with a major media source, but he did by witness, and he was fair, I thought, to both sides. And I tended to look to what he was writing first, and then kind of go to the other stuff. But
Yeah, I found one blogger out of all the press people in the McDonald case. They're all saying, governor's, throwing his wife under the bus, throwing his wife under the bus. One blogger understood maybe they are driving the bus together and wrote that story, but only one. The other problem that we had with the press throughout the trial was we stayed in a hotel a block from the courthouse, and the press was staying in the hotel as well, or a lot of press people were staying in the hotel, and I didn't recognize them. So anytime you're talking to a colleague at breakfast or in the hallway or whatever, there are press people everywhere. It was really, had to go out of your way to have private conversations in a hotel suite or in a room or something like that where you knew that it was secure and hopefully nobody with a glass up to the door was trying to listen to you. But they were always spying constantly. And they formed a scrum. I mean, we'd walk from the hotel to the courthouse, and you'd get 10 feet out of the hotel, and you'd be surrounded by literally 100 reporters, and they're physically assaulting me. They're walking up the back of your legs. They're shoving you out of the way to try to get to your client with a microphone. Fortunately, he was very used to dealing with the press, so I wasn't so much worried about what he was going to say. But I mean, with this whole group, it was like literally like a rugby scrum, doing sort of like slow walk to the courthouse, and every day to and from. And the judge wouldn't do anything about putting up stanchions or restricting these people from an area around the courthouse, basically. So every day you had to and from go through this press madness, basically. And it was fortunately a lot of people on the street liked my client. All men, women, black, white, et cetera. A lot of people really liked him personally. So they'd come up and intervene and, ask to shake his hand and this sort of stuff. So some of the news clips were favorable, but it was just unbelievable. It was really difficult to deal with in every respect, and it distracts you from trying to defend the case.
So I don't really mind a negative narrative, but I thought I would say something moderately positive. I mean, during the course of our trial, significant DACA issues were taking place and significant issues on Obamacare and votes in the Senate. And aside from some serious contretemps with the judge about whether our client could absent himself from court and whether we could get an instruction about why, he did hold a number of press conferences about those issues, and we talked to him pretty carefully. He was extraordinarily disciplined. And I must say, although the press would wait until the end of the conference to try to ask him a question about the trial, they would normally ask him relevant questions about the subject he wanted to talk about. And I was amazed at his willingness ultimately to be disciplined, to talk about the policy issues. And obviously, it isn't a bad thing during the course of your trial where you're charged with bribery to have the accused saying, despite that, I'm going to continue to do my job. But it required a lot of discipline on his part. And I will say that the press, by and large, waited until the end of each of those statements before they started asking him about questions related to the trial, which he was disciplined enough not to answer. So that's a moderately good story to say in the midst of what is otherwise a gloomy assessment of the relationship of the First Amendment to the Fourth, Fifth, and Sixth.
You know, one of the issues you always see in high publicity cases are, and I think about right now, the Cosby case that's going on, and they made a decision not to move for change of venue again. I want to talk about change of venue and what are some of the things that you think about when you're making those decisions. I mean, obviously, the senator was tried in New Jersey, which is his constituents. You know, sometimes the prosecutors will pick more favorable jurisdictions to themselves. What are some of the things you think about or you consider when you're determining whether you want to file a change of venue motion? I'm curious, did you file one in?
No, I didn't. I mean, the polls showed that McDonnell had a 60% approval rating in Virginia, even after the indictment was returned. So I didn't want to move it out of Virginia. And I didn't want to change venue out of Richmond because I wouldn't have gotten, I mean, the other federal districts in Virginia would have been much worse. And Alexandria, because the Washington Post is right there and closer, and that would have been more problematic because they were against us the entire trial. And Norfolk is a really difficult jurisdiction for criminal defendants. So I was, all things being equal, I was happy to be in Richmond, but we thought about, you know, I mean, we did obviously jury research, et cetera, and looked into a lot of issues, but the publicity didn't make me want to move the case to another state. I would rather have expanded voir dire in Richmond than little voir dire in South Carolina in this case, or some other place the case might have been transferred to. So I would always opt in favor of expanded voir dire as opposed to moving the case someplace where I got very little voir dire.
I once represented a Harvard MBA CEO in an antitrust price-fixing case, and we were talking about the jury and so forth. He was indicted in St. Louis. He was from Connecticut. The corporate headquarters were in Connecticut. And he finally said, Warren, stop the BS. Tell me, I need statistics. Tell me the acquittal rate for the last 10 years in the Eastern District of Missouri versus the District of Connecticut. And give me a chart and give me an MBA sort of presentation on that. And then we're going to talk further about whether we file a motion to change venue. Dramatic difference. St. Louis had a conviction rate of about 95, 98% for the last 10 years. Hard, when you look at those statistics, it's hard to tease out white-collar cases from bank robbery cases, at that time at least. And Connecticut, dramatically lower by about 20%. And so we filed a motion to dismiss, a motion for change of venue on that grounds. Of course, it was denied, but we used the. We just thought we'd get a better chance of acquittal statistically by a Connecticut jury, and it was going to be his home, and
Conviction is inconvenient.
that's right, and his employer was very prominent and highly regarded in that local community, and nobody, frankly, knew his employer in St. Louis, and so, but we lost the change of venue motion.
Yeah, to transfer. Yeah, well, the other issue, not only, I mean, you got to look at the two jurisdictions of the ones that are likely. I mean, if you've got the center of gravity's in Connecticut and the case is being tried in Alexandria, you might have a shot of getting it back to Connecticut. And as you say, you may want to go there because you have more defense-oriented judges, or alternatively, you know that you're going to get a better sentence in a blue state because they don't pay any attention to the guidelines in those states. So that also is a factor that impacts a change of venue or a transfer, just a transfer motion.
The risk of being too touchy-feely, if the problem of the defense if the deep, dark secret of the defense side is that occasionally defense lawyers' egos get in the way of client issues that concern their client, I think from the government side, it's sometimes self-righteousness. Now, the lawyers who tried the Menendez case, I mean, I've been doing this for 42 years, and I thought on the whole, they were decent people, decent in a moral, ethical sense. I do think that they had, just as they were willing to profit from hyperbole, they were also looking to send a message. I think the idea of trying a senator in his home state and convicting him of corruption was something they sought to do. And I think it was counterproductive to the extent that our defense was friendship. I mean, we're in a part of the country where there's a powerful, strong Latino part of the community and where non-Latino elements of the community are sensitive to those issues. Part of the friendship between our clients was that they were two men who deeply cared about Latino issues of policy, of culture, and that's what cemented their relationship. So for the government to discount that because they wanted to make a point, and the point was made, I mean, Senator Menendez's numbers went down to about 50% after the trial, but they're now back up to where they had been before, and people, I think, appreciate the job he's done, and he is a conscientious guy.
So, what was interesting.
And you
I
were
want-
not a racist in saying that they were prosecuted for being Latino.
One of the things I wanted to add is we did move for venue. We did move for a change of venue in our case. And if you look at our briefs and look at what the government filed in Stevens, it was the same. The rationale that we filed asking Public Integrity to move our case was the reason Public Integrity sought to, I mean, they switched positions entirely. So, I mean, one of the things we don't talk about because we're not supposed to talk about is we also look at who the judge is, right?
Sure.
And whether we think we're going to get a fair trial. I like predictability. Even if the judge might be harsher or less pleasant to deal with, I would rather have someone that's predictable. And that's my preference. And sometimes you get a judge that's totally unpredictable. You don't know what you're going to get from day to day, and that makes it very difficult to try your case.
Well, that goes to the point of also, you know, sometimes there are some judges who like the limelight.
Judge Ito.
Yeah, yes, Judge Ito. And, you know, sometimes when the judges get these kinds of cases, it creates a whole nother series of problems. Have you all dealt with any of that?
So the only thing I will say, because our trial judge was a friend of mine before the trial. He came to our wedding. My wife is in the back and can vouch for that. He offered more objections sua sponte than the defense and the government combined. That's all I have to say about judges wanting to be in the middle of the mix in ways that might respond to the national attention.
Look, every judge is different. I just want someone that's predictable.
I don't like predictability. I like total random chaos.
Yeah, yeah.
It's usually better for the record.
But I don't know how you control that. If a judge decides that this is their time to shine and wants to be more active in the case, that's what's going to happen.
There's no more independent judge on this planet than a federal judge who's sitting senior status. Nothing can happen. There are no consequences. So, for example, something that we sort of, during the course of the trial, there was a woman on the witness stand, there was a female AUSA and a woman from our team who were, and there was an objection and they were talking over each other. And the judge says, I'm going to get in trouble for this, but I think this is turning into a hen party. And, I mean, everybody in the courtroom, now, if a state court judge had done that, or a judge over whom any disciplinary system might prevail had done that, there would be a matter that would have to be contended with. But it just was what it was.
We touched on it just for a little bit. We talked about judges in the limelight. I think, you know, obviously they were co-defendants in your case, and you guys got along well. Dealing with attorneys and their egos as co-counsel, which I think is a very difficult issue to deal with because obviously you have no control over them, sort of. But have you ever used there are techniques, have you used some techniques to help either rein in co-counsel who may be going off the rails?
Yeah, you tell them I have a lot of friends in New Jersey. So you keep this up and you'll meet some of them.
That's what Ray kept saying to me.
No, my wife wanted to remove my ego surgically when we got married, so I don't have that issue.
Yeah, I mean, you know, working with co-defendants counsel is always difficult. I mean, I think, you know, defense lawyers understand that there needs to be only one prosecutor in the courtroom. And, you know, you hope that people will work with you and will structure their examinations and their arguments in ways that, that benefit their client, but don't unnecessarily harm or draw distinctions or contrasts with other clients. And I think, you know, and at times you've got to insist on that. You've got to have a lot of private conversations about, you know, whether you knew it or not, this really hurt me, and, you know, I hope you can avoid that in the future, et cetera. And there, you know, there are a lot of sort of individual ways to deal with it, basically. But the only time I've ever seen it work perfectly was in a case that I was in with Ray's father, a mob trial that lasted 22 months. And the clients were the ones who insisted on a strong joint defense. And they would, you know, I mean, they would tell each other to tell the lawyers, you know, do not let your lawyer do anything that hurts me, hurts my client, et cetera, or hurts another person that's a defendant in the case. And if the only thing they can do is to sit down and shut up, or they're going to do something wrong, then make them sit down and shut up. But it's critical that you try to avoid those contrasts and those problems and that finger pointing, et cetera. Because particularly in you know, if you got a large trial with a lot of defendants, there might be one person who escapes if that happens, but you know, that there really was no evidence on to begin with. But in my experience, if the defense lawyers are pointing the fingers at each other and their clients are pointing the finger at each other, or stumbling into it or doing it on purpose, it's death for the defense.
It is a sine qua non of success that lawyers find a way. I mean, we had 11 lawyers, only one combination of which had ever worked together before. And despite differences and some strong egos, I think the pole star that we have to keep reminding ourselves of is something simple. The only thing that matters is the interest of the client. It's also true that for a rare time in my career, our defense was based in truth. That is, there was a genuine friendship between these men.
That makes it a lot easier.
Which made it
when-
much easier.
When
I mean-
everything aligns and you don't have the evidence weighted really heavily on one defendant or another. This was a really easy joint defense for us, just because the defenses aligned, the witnesses were easy to break up in terms of who's going to go first or how are we going to approach this. It was easy to sit down and chart that out.
But given two men who didn't genuinely care about each other, it could have gone south. I mean, there are ways where it could have been divided, but I think they genuinely loved each other as human beings, and that makes a difference. And for jurors who did everything from watching whether the bottles of water we used were the same as the bottles of water that were allegedly in the plane for the senator's benefit, or who were looking to see whether his alleged mistress's shoes were Louboutins or not.
They were.
They were. And why? And would you get the money? All things considered, it really started with the core of being a truthful recitation that there was love and friendship between these men. And then a bunch of us who were always willing to say there's only one interest to be served here. But that's not easy, and all of us are capable of getting off the rail.
You mentioned joint defense agreements. You know, the government many times is trying to get behind the scenes. I don't know, I don't think do any of you enter into written joint defense agreements anymore?
I don't.
I did about 5 years ago in an antitrust case with a lot of big firm lawyers that I didn't know. But it's rare. It's real rare. I'd much rather have an oral joint defense agreement.
Well, both things are true, that at the end of the day, if there isn't real trust,
Yeah.
the agreement isn't worth the paper it's written on. On the other hand, we've had a succession of U.S. attorneys in New Jersey who not only respect them and don't litigate against them, but actually ask, for example, cooperating witnesses, is there a joint defense agreement? If so, we're willing to respect it. So it's kind of unique in this district that we've had a succession of U.S. attorneys who've chosen to respect them. But by and large, I mean, you don't want to be litigating a joint defense agreement somewhere. And actually, I find them useful in cases where you have a civil component,
Right.
and you're working with civil lawyers who don't, I don't know how to frame this. In 42 years, it's been my experience that the criminal bar develops an ethos of trust that exceeds that of the civil bar. If there are those of you who are civil lawyers and offended, I don't apologize for what I said, I apologize for offending you. So to that extent, it helps to delineate with civil lawyers who are in adjacent cases or who will wind up sharing discovery, what the bounds are, so I found them at least pedagogically useful in that context.
Yeah, the other issue is if you have clients who speak to, if you have Japanese clients, for example, in an antitrust auto parts case, it's often useful to put the joint defense agreement in writing because it's impossible to explain this stuff to a client. And the clients have to agree to it. They have to sign off essentially on it or allow the lawyers to be involved in a joint defense agreement. It's both my choice and my client's choice. But I think these things, the written agreements are, to someone who's not a native English speaker, I think they're completely unintelligible in many, many respects. It's very difficult. The core themes are easy to explain, but the language of these written agreements that I've seen, and I've seen many of them over the years, are really, really problematic. I think the key issue in joint defense now is whether anything that's disclosed from a member of the joint defense group, whatever I tell somebody else in the joint defense group, they can't use it, they can't disseminate it further or talk about it without our permission. That's the key. The real difficulty comes when somebody who was in the joint defense agreement and withdraws because they're obviously cooperating with the government and they're not going to be part of it anymore. If they have lied in the joint defense agreement, if the one defendant or his lawyer said the light was green, basically now he's cooperating and he's saying the light was red. The key issue in these written agreements is whether or not you can use the prior statement to impeach that person now that he's become a government witness. And so the big debate is, can you impeach lies that were told to you in the joint defense context, or can you not use anything ever, period, without the permission of the person who was the source of the information? I think that's the key debate I see in the written agreements these days that people float around.
And you sort of get back to trust. I used to think the withdrawal provision was important, but the truth is if I'm in a case with Hank or Kirk and I call them up and they don't return my call, that's a
Nobody has
pretty
to
good
tell you.
indication, better than a formal withdrawal.
Right.
Right. Well, speaking of that, I mean, many times, you're in a joint defense, and in federal cases, obviously, people do fall out and cooperate. And I've seen it affect friendships. I've seen it affect a lot of things. We looked today, and Sandy was talking about, the Mueller investigation, and obviously, at least it's been recorded, that many of the lawyers have been reporting back to the White House, and now they're falling out. Have you ever had experiences with that, and is there anything you can say about what do you do when these people fall out and you're sort of left, and everybody knows about it? Have you ever had that, where you're in a joint defense agreement, and then everybody knows that they've all of a sudden pulled out and are cooperating against your client? You may not have happened. Never happened?
Yeah, I've had it. I don't know what you can do about it. I mean, I've showed up on the day of trial and it was an empty seat. I've even showed up once on the day of trial and the lawyer was there and his client wasn't, which raised some 4.2 issues that we litigated ad nauseum. So at the end, I just want to know if Jared would roll over on the president.
Look, I don't know what you can do other than try to explain to your client what's happening.
Right.
And how, whatever was shared before is not supposed to be used, and make sure your client understands the full implications of what is likely to then go on.
I'll tell you where it manifests itself. I mean, I don't know how many times I've had the conversation with a new client who said, Hank would never turn on me. And I would say, let me explain to you what my experience in life has been. No, that people can be close as brothers and sisters. They can be lovers. They can be anything.
Yeah.
But if enough pressure is brought to bear, only a minority of human beings will withstand that pressure. If it's not going to jail or going to jail for months instead of decades, very few people will withstand that pressure. And so your assumption has to be that any human being is capable of turning. And that's a dark view of human nature, but it's certainly the view I've come to and the one that you have to try to inculcate clients with, because they've been working for cheek by jowl, and if perchance they were committing a crime, they've been very close and intimate. And the notion that you can't further compromise yourself by assuming strategically that that person's going to be with you all the way down the road, that's where the cheese gets binding, and that's the conversation. I'm assuming you've had that conversation. Yeah.
All right.
It's Herc.
Absolutely.
We've been going on for quite a long period of time. Folks must have questions for some of the panelists. Anybody?
Yes.
It shows how difficult that was for a
They,
two-month fraud trial or more than that
with,
to represent somebody in jail.
so he was in custody in Newark in essentially a state lockup, and they would bring him in every morning. Look, it was a document-intensive case, you know, a lot of emails, a lot of documents. So we would have binders of documents that we'd want to look at with him. A lot of the prep work that we did, we had luckily done prior to him being remanded into custody. But we got lucky in some respect. It made the job of trying the case a lot harder, but we had a good client, good family. They made it easy, but it, you know, it was not ideal, and it certainly would have made it a lot smoother had he been out on bond.
It did help that we worked out a modus vivendi with the marshals so that the clients could meet together as long as one of us was present, which was at least somewhat helpful, I would think.
Yeah. I mean, in a long trial, you know, there are just times when you need to just sit with your client and talk about what's happening, and we were able to do that, but we had to do it in lockup. By the end of the trial, the marshals were able to let me go back because they had a holding cell. Were able to let me go back and talk to him during breaks. But most of the time, they would take him down in the basement of the courthouse, and you'd have to go down and log in with everybody else. And, you know, you'd wait in line and wait for a room, you know, get to know all the public defenders and everybody lined up, and wait for your turn.
Most white-collar defendants, for the most part, aren't incarcerated, which makes it a lot easier. With that said, you know, everyone here does lots of white-collar cases versus high-profile white-collar cases. And this is about lessons learned. What would you say, if you had to give one tidbit to the folks out here, the most important lesson you've learned from doing high-profile cases? That's a fun question, isn't it? I didn't prep them for this, by the way.
The flip remark is, don't set a trial in Richmond in August. That's something that I learned. No, I mean, I learned, I mean, just how vigilant you have to be at 20 hours a day because of this overlay of the profile in the case and the press in the case. It just makes things much more complicated. And you have to worry about a lot of things that in a normal trial are not of concern. The other thing that about white-collar cases, and in particular the governor's case, that was incredibly important to me throughout it, was pushing the concept of character, of his good character, bad character of the government's witnesses that were not my client's family or staff or friends, et cetera. And that's something that we tried to do from the start of the case, I mean, to the extent we could in the press, a little bit of that, but certainly all through the course of the trial. We were, and through the sentencing and forward, we tried to do everything we could to expand on his character traits, which were spectacular, actually, in many ways, and to, you know, by the same token, the flip side of this is trying to score points in terms of bad character of the government's witnesses or the key witnesses against us. But that overlay, I mean, my ultimate belief about any trial is that it is always about the character of the participants in the trial, the clients, the lawyers, the judge, everyone that plays a role in the case. And if you come out ahead on that score, then, you know, you got a much better chance of winning. You know, jurors in our case who were interviewed, we were not allowed to, but they were interviewed after the trial by the press. And, you know, a lot of them said, my client testified for 5 days. He was on the stand for 5 days. And you can be sure that he never said he was guilty at any time during those 5 days. And several jurors basically said, we believed everything he said. They still convicted because they asked themselves the question, would he have gotten these gifts or loans if he weren't the governor? If that were the legal standard or test, we were dead on arrival. You know, that's what the case ultimately was all about at the end of the day. What was the legal standard here? You know, we preserved that through the course of the trial, and ultimately, you know, after a long 3-year slog, prevailed on that. But so I guess two things to me is the whole character concept, number one, and number two, if you've got a fabulous issue, a fabulous legal issue, the one thing I was most diligent about was never, ever taking a chance of injecting or allowing to be injected any evidence in the trial that would have undercut our core theme. And somebody said before about sometimes you don't cross-examine people, but our theory was that there was no official act that required, in our formulation, putting your thumb on the scale in terms of a decision that somebody that McDonald controlled made. And the formulation in the Supreme Court is ultimately pressure or advise. That's their version of our putting your thumb on the scale. There were people that testified for the government that I knew. Had I asked them, did you feel any pressure, et cetera, from the governor when he did X or Y, et cetera? Did you feel any, you know, that he was trying to send you a signal or anything like that? I knew basically that that if I went down that line with these people or tried to get them to say no, 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 which is what they had told me that they were probably going to say, that the government on a redirect was going to kill me on that. So I made the choice during the trial. There were a couple of witnesses that hurt us a little, but not terminally, and I just didn't cross them at all to give the government the chance at the redirect. And we preserved this. There was not a single person in the trial that ever said he was pressured by the governor or felt that they had to do what he asked them to do, or there was a signal when, you know, meet with this guy, hear him out, as opposed to meet with him, hear him out, and do what he wants at the end of the day. So it worked. The record was pristine on this particular issue, and we knew from the beginning that this case was likely, we hoped to win it at the trial, hoped to win it in the Fourth Circuit, but we knew the case was going to the Supreme Court if we lost below, period. We knew it was going to be a cert-worthy issue, and we played it for that all the way through the trial. So if you've got, you know, if you got a really good issue, you got to make sure that you preserve it. I mean, obviously, I would have preferred to win it sooner, but it's good to win it ultimately.
You want me to go? I think my takeaway is don't get distracted by all the noise and everything else that's happening. Just focus on the case. So I intentionally, and we had the equivalent of the press, you know, lined up every morning and afternoon. Tried to get out away from the courthouse quickly, get to my work, get it done, and then look at the media last and not get overly distracted by all the other stuff and just focus on trying the case. Because it was easy to get sucked into, you know, one bad news story that generates 10 more bad news stories. And I mean, you pay attention to it, at least I did, because I thought I could have jurors paying attention to it, but not get sucked into it where it ate up my time, and just focus on.
And this
You
assumes
know,
the jurors are
good.
not going to follow what the judge tells them to do about not paying attention to the media.
Yeah.
I think that it's two things. One is a level of discipline. I mean, because you have to be aware that all this other stuff is going on and the jurors are going to pick up random facts and notions from other places. During the voir dire, for example, the judge did keep a fair amount of salacious material out of the trial. The jurors knew about it anyway, because at least the ones that we talked in voir dire seemed to be pretty much aware of it. So you're aware of the backdrop of all the stuff that doesn't come in through the front door and that you may or may not be able to combat directly. And the other is, what is it that makes it a public trial? I mean, a high-profile trial could be because, say, Casey Anthony, which is a case where it's the event itself, a mother and a child, and what is that relationship? But where it's because of the persona of the accused person, what does that mean? That is, what is it about Menendez that they're going to affect jurors' expectation? Does he have to testify? Turns out they weren't miffed that he didn't testify. They thought the government didn't make a case to answer. But the pressure surrounding a guy who's a lawyer, I mean, one of the issues was whether he had filed certain reports, signed certain reports correctly. Here's a lawyer who's chair of the Judiciary Committee in the past, a really brilliant guy. What are the expectations jurors have of that person? And all along the way, the thing we alluded to earlier, which is there is always this sense that this person wants to guard that persona as much as they want to be acquitted. And it's a subtle tension that you have with an accused person. And to some extent, he has some rights in that regard, although whenever there's a choice, I vote for liberty over the persona. But still, this is a person, and I'm not talking about a made-up persona. This is a guy who was real. I used to kid him. I guess it wouldn't be a great surprise that I'm a Democrat. And I was associated with another wing of the Democratic Party in Hudson County. And I used to tease him that most of the time I saw him growling on TV. Because that's sort of his persona. He's always fighting about some issue. He's not a sweetheart of a guy in that sense. And what do jurors expect of that person? And how does that expectation affect the way they're going to see evidence when what we were talking about was a genuine, loving relationship between him and another guy? And I think that public persona plays a role in the trial at very subtle levels. That's why it turned out to be a high-profile trial, and that's something you always have to be. And I think one of the things we were pretty good about consistently was, to the extent that we had differences over tactics or strategy, was always what helps us prove the friendship, and that everything. So the bunk beds became really important. I mean, here's a high-profile guy who doesn't stay in a fancy hotel but sleeps next to the bunk beds of his friend.
Any other questions? If not, I want to thank everybody here on the panel. It was great. Thank you.
Thank you all.